Hi guys, welcome back to Nairobi Legal Insights. In our video today, I'm going to be breaking down for you insolvency law. Basically, this formed a central part of commercial transactions, question number 1 of ATP 2022. And so our focus is going to be on insolvency and highlighting the key points that can guide you to overcome an insolvency question and how to actually approach such scenarios. When it comes to insolvency, specifically in Kenya, we have the Insolvency Act 2015, and some of the key things I'm going to be discussing in this video specifically are answers to the Commercial Transactions Paper 2022. I want to begin with the concept of liability of contributories. Now, when I talk about liability of contributories, a closer look at the 2022 commercial transaction paper, there was a fact that stated that some of the shareholders or members that were given shares had only partly paid for those shares. So that's a key point to note, partly paid. So liability for contributories simply means that when a company is undergoing liquidation, then whether you're a former member or a present member, you're supposed to pay up any amount that you did not pay up at the point when shares were issued to you. So former and current or members of a company under Section 385 are required to pay up the balance for the shares that were issued to them. And so if you read that paper closely, I think paragraph 1, this is a key concept that addresses that question. And again, for the future as a student of insolvency law, remember the concept of liability of contributories. You must pay up whatever amount that you were meant to pay at the point when shares were issued to you. The other concept I want us to take seriously is in insolvency, you need to know that there are certain transactions that can be avoided once a liquidator has been appointed. And some of these transactions involve fraudulent trading. So what we mean by fraudulent trading is that directors conduct the business of a company with an intention of defrauding creditors. So if such a transaction can be depicted from a set of facts, maybe directors are selling off property, they are selling off key assets of a company in a bid to leave the company as a shell, then there will be a need for these directors to be held liable, and this is what we call fraudulent trading pursuant to Section 505 of the Insolvency Act of Kenya. And the other thing we can talk about is wrongful trading. Now, directors have a duty to act in the best interest of a company. They have the knowledge to know when profits are going to be realized. They have the knowledge to know when a company is struggling. And so directors have this duty and obligation to ensure that once they judge, based on the experience, that this particular company is likely not to survive the next 2-3 years, then they should surrender that company to either administration or even opt for liquidation. And so if you continue trading and you know that the company will not survive liquidation, then you can be charged for wrongful trading and you'll be liable as a director of a company. And this is Section 506 of the Insolvency Act of Kenya. Now, the other concept that could arise again is a sell at undervalue. Remember that sometimes when a company is about to fail, directors may rush to make decisions to sell off assets or offer shares at an undervalue in a bid to get some money to continue the operations of the company, and that is under Section 682. So any transaction that is entered into by directors 2 years preceding to a company being considered insolvent will be avoided. This transaction can be avoided. Money can be recovered because this was a sale done at undervalue. So these concepts now guide you to see how directors can be held liable for their actions and how a liquidator can be able to go after those transactions and even recover the money that directors might have gotten in the process. So the key things that arise here is section 385, 505, 506, and 682. And some of these points specifically, again, address the question on commercial transactions 2022. The other transaction that could be avoided is an invalid floating charge. And an invalid floating charge is a charge created within 1 year preceding the act of insolvency. Remember, companies borrow money, and that is one way of accessing financing. So a company could either have debt financing or equity financing. But in the event that a company goes to a bank and then it borrows money and the security is a floating charge. Now, I want us to first understand what a floating charge is. If a company has assets and the security is a floating charge, is in form of a floating charge over its assets, what this means is that there is no specific security. So the floating charge is it's all over the assets of the company. And once the company fails to make the payment as agreed in the terms of that loan, either from a bank or any financial institution, then the floating charge will crystallize upon one asset of that company. Crystallizing meaning that one asset will be selected to recover money, that the company had borrowed. So upon default, the floating charge crystallizes, and then on that specific asset will be sold so that the company gets back its money. So I hope that concept is clear, but I'll be explaining much more on this in more videos to come. But the key takeaway point here is that if a company entered into a floating charge 1 year before insolvency, then that charge could be avoided. The other thing is that you need to know what we call preferences to junior creditors. Let's say a company is struggling, it has several creditors, and then it chooses to pay back a junior creditor. Remember, we have a hierarchy within which unsecured creditors are to be paid back. So if a company prefers one specific creditor who even comes below in terms of the hierarchy, 6 months to insolvency, this person is paid back. And in most cases, it could be a shareholder who paid a company, or rather who gave a company some money in form of a loan, and that junior creditor is preferred. That transaction will be avoided because there was a preference when it came to paying back that specific creditor. And we'll be looking at the second schedule of the Insolvency Act that basically outlines the hierarchy within which creditors and secured creditors are supposed to be paid back. We also have a concept that we call the pari passu principle that is followed as far as paying back these creditors is concerned. And we shall be breaking this down as far as the second schedule is concerned. As you can see, I've provided the sections here. You can see we have section 683.4, and I've also talked about section 687.2. Now, let me stop there for as far as these technical concepts in insolvency are concerned, and shift our attention to alternatives to liquidation. Remember that liquidation, once a company is undergoing liquidation, that's the end of it. But before you even get into things such as liquidation, a company may have options on how it can salvage its current situation. Basically, how do you actually restructure this company to save it from bleeding? And the alternative we might have include things such as company voluntary arrangements. A company can enter into an arrangement with its unsecured creditors. They agree that, look, we are facing a financial difficulty. Give us this amount of time, maybe extend the period within which we are supposed to pay you back. And the intention of entering into company voluntary arrangements is so that these unsecured creditors strike a compromise with a company and ensure that the company continues operating and it pays back these unsecured creditors their money in bits. Remember, they're also avoiding a situation of liquidation where they may not be able to recover all that they had lent to a company. So also some companies, once they sense a bit of financial difficulty, they may go for what we call prepacks. And prepacks involve sometimes a company, it sells off some of its assets, and then it gets this money and pays back its creditors. So the advantages of pre-packs is that, before the public knows that the company is struggling, the value of the assets is still good. I mean, the market value of the property that belongs to a company is still valued very well by the members of the public. But once people start to know that a company is failing, its value drops. The shares drop. Even selling off the assets becomes a problem. So to avoid that future occurrence, what companies opt to do is they go for pre-packs, sell off some of the assets prior to informing the public, or prior to going into administration and all these other insolvency proceedings. And when they sell off these assets, they're able to get money to pay back their creditors and control the situation before it actually gets out of hand. And of course, the other alternative we could have to liquidation is administration. And once administration is well managed, a company can be able to survive once again. Because administration is about restructuring. It's about looking at the administration of the organization, looking at the loopholes, fixing the gaps to ensure that the company bounces back. And also the advantage of this administration is that we have something called a moratorium. And once a moratorium has been given to a company during the process of administration, what it does is that you cannot bring a suit against a company as a creditor, and all proceedings or cases against the company are stopped. So there's what we call stay of proceedings in law, meaning that the company has some sort of a breathing space to reorganize and re-strategize while no one is actually taking it to court, no one is after it. So within this period of a moratorium, a company can be able to reorganize and up its game. Now, I want also to comment on shares. Remember the question on ATP, commercial transactions 2022 touched on shares. We need to note that also that, remember, shares is as good as property. Share is property. And we know, even as per the Constitution of Kenya, you have a right to transfer your property the way you wish. And so shareholders in a company have a right to transfer their property and sell their shares to other members of the public. You forgive me for that. Especially for public companies, you can sell off your shares the way you wish. There might be some restrictions, maybe in the articles of association or the articles of a company state that you cannot sell shares to outsiders if it's a private company. Maybe they have put in a specific clause that before you exercise your right to sell shares, ensure that those shares are sold within the members of the company first. So these are what we call preemptive rights. First sell the shares within us. Then if that fails, proceed and sell to outsiders. If that clause is not there, shares are fully transferable to other members of the public. So as I come to the end of this video, some of these concepts could assist in addressing the question of commercial transactions 2022. And I'll be making more videos on commercial transactions in Kenya. But in case you have any question, feel free to reach out, drop a comment so that I respond to you. And of course, don't forget to subscribe to Nairobi Legal Insights so that you receive notifications every single time you want to watch a new video upon me posting it. This has been a very interesting session. I love insolvency law and financial law, and I'm passionate about making sure that you also benefit from what I know. Thank you so much. See you next time.